Well, as I was telling you, schools are shut and an international travel ban will kick in Wednesday as per the national disaster declaration made by President Cyril Ramaphosa in the battle to contain the global pandemic that is the novel coronavirus. Some of the measures will limit the rights of individuals around travel and gathering, for example, for religious and other purposes. This includes the right to privacy, freedom of movement, for example, assembly and even religion, as I was saying again. For some analysis now, I'm joined by constitutional law expert Michael Osborne from Cape Town, joining us via Skype tonight. And we are, Michael, speaking to everyone via Skype as part of our measures here at eNCA to try and contain as much as we can the spread of this new coronavirus. But to the question about the rights of individuals during this time of a national disaster, what are the limits?
Good evening to you. There's a number of different limits depending upon the kind of restrictions we're talking about. Perhaps most fundamental is limitations on the right to freedom of movement, protected under Section 12 of the Constitution. And that would come into play where, for example, you have non-voluntary quarantine, non-voluntary isolation, and there's a network of laws and regulations which do permit limitations on movement and of assembly, etc. Those laws would always be subject to the Constitution which on the one hand protects basic rights like the right to privacy and the right to movement, but on the other hand provides for the limitations of those rights, provided those limitations are proportionate, rational, fair, and non-discriminatory. So one can imagine the possibility of ongoing debates, as we've seen in the United States, between those that say that the particular severity and social damage that may be caused by this virus are of such a nature that they justify the temporary, and I emphasize temporary, overriding of the fundamental constitutional rights to be found in the Constitution.
Am I right to say then, Michael, that much of this hinges basically on an argument or assessment of the rights of the individual versus the safety of a nation or the broader population?
Yes, that's precisely correct. There's plenty of precedents from overseas in which it's recognized that in exigent circumstances, collective or national interests may override private interests. But the courts are always available, and the courts may well be or could be called upon to make an assessment as to whether the particular regulations or restrictions are proportionate and rational. You have, for example, regulations promulgated under the National Health Act, which allow for effectively involuntary testing and quarantining. Now, it's entirely possible and indeed likely that those will not be found to derogate in an inappropriate way from fundamental rights. Then you have the National Disaster Act announced on Sunday. They too allow for fairly restrictive limitations, for example, on the right to public gatherings to no more than 100 people. Now, that kind of limitation would be unthinkable, except in the circumstance where you have a declared condition which is fundamentally threatening to the broader public interest, as it appears we face right now.
And that brings me rather to my next question then, Michael. A lot of people reacting to the travel ban on foreigners coming from the high-risk areas, saying that even South Africans who've traveled to countries like Italy, Iran, China, the UK and US should not be allowed to return. But of course, the Constitution does not permit a country of origin to enforce such a law.
Yes, that's entirely correct. One of the rights in the Constitution is specifically that citizens, not anyone, but that citizens may not be denied the right to re-entry. But having re-entered, these citizens will have to accept that the implication of their re-entry may well be temporary isolation or quarantine. And again, that's likely to be regarded, I would think, as a necessary and justifiable limitation on a strictly temporary basis, so long as the objective conditions of the crisis would seem to warrant that.
And there's another story developing in Gauteng where the Provincial Health Department has had to approach a court about a family that had the husband who refused to be tested for COVID-19 after his wife and daughter had tested positive. They had then refused quarantine and now are being taken essentially to court by the government to force them to comply. What are the parameters, what are the lines that govern those kind of situations, especially heading into weeks where we're going to see much more testing and likely many more people being placed in self-isolation and indeed quarantine?
Yes, one can expect there will be such contestations, and people like the family you mentioned will be invoking their right to privacy and family life under Section 12 of the Constitution, and their rights to freedom of movement. Now, the right of freedom of movement and liberty of the individual, except in accordance with an order of a court of law, are sacrosanct. But you do have a provision, for example, under regulations to the National Health Act, that where a person resists quarantine or isolation or testing, there is a provision for the government to go to a court of law and get an order which compels them to comply, even involuntarily, to such restrictions. And one can think of this by analogy, for example, to the Mental Health Act, where provided a magistrate under the or with the consultation of two medical professionals deems that the safety of the public or the individual would warrant this violation of freedom of movement, that may well be upheld by the court.
All right. Constitutional law expert Michael Osborne Skyping in from Cape Town.